Come this damn fly. Sure that hit. Right up in here the damn. Shh. Greetings, 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 greetings. It is I, King Clifford Jefferson, ascended of Godfrey, the fifth counterband Jew, the son of Folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ. We greet you in the name of our forefathers, our ancestors, our predecessors, our children, our mother, our fathers, our sisters, our brothers, our uncles, all the above. I greet you in the name of my queen, Sister Galveston from the House of Galveston. I greet you in the name of all those who are all trying to get understanding of what it is that we here and called to do here at the Third Temple English Church of England. It is July 31st, 2024, which is equivalent to the Berber calendar 2974, and we greet you in the name of love. All right. This is a beautiful lecture today, and the name of the topic is The Choice of Citizenship is in Your Hands. Choose wisely. Once again, the choice of citizenship is in your hands. Choose wisely. You know, I've been on a rampage for the past couple of weeks in regards to getting this information out about who we are as Anglo-Saxon Berbers on the physical level as well as on the molecular level. All right. And all of it is needed for your ascension. This one particularly is about bringing full circle the people's understanding about citizenship, people's understanding about citizenship. Your understanding about citizenship is wrong. All right. And it's very sad that 99.9% of the people are under the same understanding of citizenship, which is the wrong understanding about citizenship as a result of the requirement of citizenship. And that's what we're going to talk about today. Okay? So it's very important that you pay attention. For this video, once again, is called The Choice of Citizenship is in Your Hands. Choose wisely. Reason why we say that is because it's really our individual choice, what you decide in regards to your citizenship here in what we call now North America. I don't care who you are. All right. If you're an individual of your organization, you are obligated to place on the record your citizenship. And there's only two forms of citizenship: nationals and aliens. That's the only two: nationals and aliens. You can call a naturalized citizen, national, but in the true sense of the word, he is an alien. All right. So it's your choice to interpret the term citizen and the meaning of the word citizen relative to what we call your legal status as a person. All right. So I'm not going to hold you long. This is pretty much a camelback off the past couple of lessons I did today. But this is to show you that here in what we now call North America, the only true citizen is the Anglo Saxon Berber. I'm gonna go to a couple of sources to validate that, but as always, I like to use Wikipedia because Wikipedia is baby food for all those who consciously are actually babies. And 99.9% of the humanity are consciously babies because they don't understand the simplest, the most important term that can be even deemed was citizenship. All right, so this is what we're going to discuss today. Hopefully, by the time this lesson ends, you'll have a better understanding about the choice that you have to make in this day and time. So, without further ado, let's get started. Once again, I never came to change the law, but to fulfill the law. Nothing that I present today was written by me. It was already written. I just went through it, uh, uh, used the process of mathematics called abstraction, break down the structure, and brought the truth out of the structure that was created through a veil of ignorance for all those at that what we call the original position, which was based upon the veil of ignorance of who you truly are here in North America, based upon your citizenship. So let's get started. I'm gonna draw from Chisholm versus Georgia. We're gonna use that as a template because in this case, it explains in totality the problem that we're having in regards to the type of citizenship that the people have versus the type of citizenship that they should have. All right. We're going to draw from Chisholm versus Georgia. I actually went through that case and extracted the information that's pertinent to this lesson, and we can read it word verbatim. Okay. I didn't add to it. I didn't take it away. If you was to correlate it with the actual case law, it would be synonymous. All right. So let's get into this. Let's get into the nitty gritty. Once again, I didn't put none of this up here. Whoever did put it up here must be watching our lessons. I truly can say that, right? So you can take this to Brother Truth, Asher Duke of Tears, Canaanite Moors, the Moors Science Temple America, Sign Letter Studios, Sambar Sudasetti, the House Wicked of Mind, Brother Reggie, as well as the Know the Ledge, and see if they will reveal this type of information to the people. Let's see. It's right here. The most basic common understanding about your legal status as a person. And one is either a national or an alien. Pay close attention. Citizenship is a membership and allegiance to a sovereign state. Once again, I repeat, citizenship is a membership and allegiance to a sovereign state. Though citizenship is often legally conflated with nationality in today's Anglo Saxon world, international law does not usually use the term citizenship to refer to nationality. These two notions begin conceptually different dimensions of collective membership. So, based upon your affiliation with a group, determines the meaning of how that term nationality is being used. Okay? In today's Anglo Saxon world. I didn't say that, they said it. Okay? We're Anglo-Saxon Berbers. Somebody put up here and edited Anglo-Saxon world because I looked up citizenship before on Wikipedia and I never saw that before. So thank you whoever edited this on our behalf. All right. Very, very, very important for you to understand that. Okay. So citizenship is membership through allegiance to a sovereign state. Over in the corner, the right hand corner of the box, you see certain legal phrases that we all need to understand. Legal status. Legal status is the status or position held by an entity as determined by the law. It includes or entails, hence that word entail, a set of privileges, obligations, powers, or restrictions that a person or a thing has as encompassed and in or declared by what? Legislation. All right? Person. A person is a being who has certain capacities or attributes such as reason, morality, consciousness, self consciousness, and being a part of a culturally established form of social relation such as kinship, ownership of property, or legal responsibility. So, this is what the totality of what citizenship inquires. All right? So, this entails once again, I like the word intel because intel, according to law, is an estate that cannot be sold, mortgaged off, lent off. All right, that can is only reserved for heirs, descendant, as a result of what we call a birthright. A birthright is the concept of a thing being due to a person under or by a fact of their birth or due to the order of their birth. These may include rights of citizenship based on the place where the person was born or the citizenship of their parents and the inheritance right to property owned by the parents, ancestors, descendants, etc. Okay? That's totally different from a nationality because a nationality doesn't necessarily denote to a birthright based upon the use of the word nationality, as we're going to see used for those who are United States citizens. And then you have what we call immigration. Nationality deals with a term for citizenship, but it not always include a birthright that comes along with it. All right? You got two terms, just sanguineous, born by the blood, and just soleil, born on the soil. You need both of them to have a birthright. Once again, you need both of them to have a birthright. You only need one of them, i.e., just soil, to have a nationality. And immigration, you need just sanguineous by part self. Immigration, you don't need either. Okay? You don't need either. All right? Because in America, you don't have a birthright in North America because the nationality does not have the meaning of what nationality means in other countries. Okay? Very important. Because citizenship means an allegiance based upon your membership to that sovereign state or that sovereign countries or the states within the country, which today they call the Anglo-Saxon world. All right? The Anglo-Saxon world. Very important. Everyone needs to note that. So they're saying Anglo-Saxon world, that should be synonymous with the Anglo-sphere, right? That should be synonymous with the Anglo-sphere. The Anglo-sphere is the Anglo-American sphere of influence with a core group of nations that today maintain close political, diplomatic, and military cooperation. All right? While the nations include different sources While the nations included in different sources vary, the Anglosphere is usually not considered to include all countries where English is the official language. So it is not synonymous with the spirit of the Anglophones, though commonly include nations are those that were formerly part of the British Empire and retained the English language and the English common law, but not the English ancestry. That's very important for you to understand and based upon your legal status as a person here in North America. So let's draw from Chisholm versus Georgia, which deals with citizenship based upon all the requirements that citizenship entails, as well as all the benefits that what citizenship entails, based upon the three classifications. One dealing with birthright, one having a nationality, which also include a birthright, and one that just have a nationality, and one that's just an immigrant. So when one comes over to a country that's not based upon a birthright, based upon the nation, that means that you can be a foreign national, which all the terms we're going to discuss today in this lesson. Let me get a thumbs up. All right. Let me get some questions in the chat when you get time, as well as greetings, Archbishop Belmont from the House of Belmont, as well as your donations are warranted. Your gifts, donations, free and common soakage, send that to the Third Timothy Church of England or $ Clifford Jefferson L. All right. It's most definitely needed. All right. So we know that the Anglo spirit is not the same as the Anglophone. The Anglophone is based upon the people who speak the English language, which the majority of foreign nationals do speak English language, but they are not English people, and they did not originate it in the Anglo spirit. Okay, very important for y'all to understand that going forward with this lesson. And we already know we went yesterday and we talked about the English overseas possessions. All right. We talked about the English overseas possessions. I'm not going to go through that today as a result of the time I have, as well as the information I have to cover. All right. So we're talking about citizenship. All right. Citizenship. All right. For for one's determine one legal status as a person. And there's only two types of status for that entity. It's called nationality, or either you're an alien. Okay? You're a national or an alien. And we're not talking about in other countries. We're talking about here and what they deem what we call North America. So that's our focal point, okay? Very, 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 very important for you to comprehend what I'm saying. I'm going to go very slow. I'm going to go very slow for everyone. We started off yesterday talking about alien. Aliens are also receive treatment very similar to the treatment that United States citizens receive in the context of the judicial system. So not in the eyes of the legislative, not in the eyes of the executive, because they created the laws governing citizenship. All right, but in the eyes of the judicial system, because judicial upholds the laws that are passed by the legislative or the laws that are passed by the administrative executive branch, which are actually what the government functions under now, contrary to the Chevron doctrine that was overruled, which put a tombstone on the administrative government. All right. So we see that the Fifth and 14th element, the Fifth and 14th Amendment of the United States Constitution apply to aliens residing within the United States. All right. As such, the courts guarantee all aliens the rights to due process of law and equal protection of law. Courts have generally construed the Fourth Amendment as applicable to aliens as well. The Fourth Amendment prohibits the government from conducting unreasonable searches and seizures. So pretty much we know that the 14th Amendment deals with those who were emancipated from slavery. All right. We understand the Naturalization Act of 1790 deals with those who were part of what we call the United States government when it was founded in 1790. And we know the Immigration Act deals with immigrants. And under those three terms, they all amount to aliens. Okay? Aliens. So please, you have a choice to make today, brothers and sisters, in regards to your citizenship. All right? So choose wisely. All right? Alien law. This is alien law we're talking about. In law. An alien is any person, including an organization. You better understand what I'm saying. So all you people part of these corporations, i.e. organizations, you're still considered in the eyes of law an alien if you haven't established your legal status as a legal person associated with a national government. Okay, a national government. All right. So it says in law, an alien is any person. I don't care who you is, including an organization that you're part of, who is not a citizen or a national of a specific depending upon the continent or region. More generally, however, the term alien is perceived as synonymous with a foreign national. Okay? A foreign national. So if you're a foreign national, according to the law in North America, you are still an alien. The only way your national rights as a foreign are reserved is by some type of legislative law that protects you. And you can't use the state law, you can't use the United States law, you can't even use international law. Why? Because it all denotes to aliens. Okay? Aliens. They're not going to tell you that. You have to know this for yourself. Let's see. Different countries around the world use various terms for aliens. The following are the several types of aliens. So choose one. Legal aliens, any foreign national who is permitted under the law to be in the host country. This is a very broad category which includes travel visas, holders, foreign tourists, registered refugees, temporary residents, permanent residents, and those who have relinquished their citizenship in or nationality categories of legal aliens include temporary resident aliens. So they talking about legal aliens, temporary resident aliens, permanent resident aliens, non-resident aliens, alien enemies, undocumented aliens. Keyword alien enemies and alien friends. All right? Alien enemies and alien friends, which are some of the classifications in regards to citizenship. But in the English law, we refer to citizenship as in regards to the common law jurisdiction. This is what it states. An alien in English law denotes any person born outside of the monarch's dominion and who did not owe an allegiance to the monarch. Y'all better listen very, very close. Aliens were not allowed to own land and were subject to different taxes to subjects. The idea passed on in the Commonwealth to other common law jurisdictions, which you now call a republic form of government. All right? So an alien is anyone who do not honor the monarch. Okay? In the United States, this is what it says. Let's see. Under the Immigration and Nationality Act, INA of the United States, the term alien means any person not a citizen or national of the United States. People born in America, Samoa, or Swing Island are statutorily non-citizen nationals. Others, such as Native Pala and Marshall Island, are legal immigrants and aliens for the Immigration Nationality Act purposes. Every refugee that is admitted to the United States under Title 8 United States Code Section 1157 automatically becomes an immigrant and then a special immigrant after receiving a green card. This is what's going on today. Based upon the border crisis, immigrants are coming over and they're receiving a nationality here in North America because they are considered immigrants. Same word, no different. So they also said that alien, what it said, a alien, what was it? Alien refers to a foreign national. So let's look up the word or the term foreign national. A foreign national is any person, once again, including organizations or any person belonging to an organization that's based upon foreign laws, foreign rules, foreign uh, uh, statutes, foreign treaties that don't apply here in North America, then you are an alien who is not a national of a specific country. For example, in the United States and in the territories, a foreign national is sometimes someone who is neither a citizen nor a national of the United States. The same applies in Canada. Let's see why. United States, the term foreign national, and the same as alien, is not defined in the Immigration and Nationality Act. Okay? The term foreign national is not defined in the Immigration and Nationality Act, which instead uses the term alien to cover many classes of people who did not qualify as nationals of the United States Americans. All right? As nationals of the United States called Americans. So if you call yourself an American, you are considered a national and not an alien of North America. But under a broader look or under the microscope, you are in fact indeed an alien. Let's see why. The term foreign national is used in U.S. election laws to describe a person who is prohibited from contributing to federal campaigns. For the purpose, the term foreign national means an individual who is not a citizen of the United States or a national of the United States. I repeat, the term foreign national means an individual who is not a citizen of the United States or national of the United States as defined in Section 1101, quotation A, quotation 22 of Title 8, and who is not lawfully admitted to permanent residence as defined by Section 1101, quotations A, quotations 20. All right? So let's look at Section 1101, quotation A, and quotation 22 to see what they define a national as contrast to what we call an alien, because based upon our assumed understanding, they are not the same. And I'm telling you, upon the microscope, they are the same. Let's look. The term 21 definition, Cornell Law School. The term national means a person owning permanent allegiance to a state. Okay? Once again, a national means a person owning permanent allegiance to a state. What does this say? Once again, the term national means a person owning permanent allegiance to a state. National of the United States. Listen, y'all. National of the United States. The term national of the United States means a citizen of the United States, or B, a person who, though not a citizen of the United States, owns permanent allegiance to the United States. So, as a national of the United States, you are not a citizen, but you just owe permanent allegiance. And permanent allegiance is the same laws that apply to immigrants. All right, it applied to the states, it applied to the colonies, it applied to this government because that's what it was based upon. All right, aliens, very, very, very important. So the term national of the United States means a citizen of the United States, or B, a person, though not a citizen of the United States, owes permanent allegiance to the United States. And we know that the word citizenship applies to one's allegiance to a sovereign state. Okay? A sovereign state. It's very important that you understand that. The term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. Did you hear that? The term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. So a national in North America is a naturalized citizen, just like an immigrant who comes over here under an Immigration Act and go through the process of naturalization to be considered a national, which has nothing to do with actual citizenship, but just your permanent allegiance. I hope that makes sense to everyone. Okay? I hope that makes sense to everyone. Because if you're an alien, you cannot own property. Okay? You cannot own property. Let's get through it. Let's see. Let's go to our pivot. Chisholm versus Georgia. We're going to draw from this case again as our microscope. Okay, we're going to look at this situation dealing with citizenship through a microscope, because we understand that your legal status as an individual or person, part of an organization, determines what type of due process of law you get in regards to your protection at law, in regards to your rights, your protections, your ability to own property, your ability to sue and be sued, etc. All right. So this is what we're going to talk about today, based upon your citizenship. All right. Your citizenship. And look at what the Supreme Court said in the 1793 case that goes back to the founding of the United States, the founding of the 13 colonies, all right, which were nothing more than people who immigrated to North America classified as naturalized aliens who are actually immigrated here for some type of legal status, which was not based upon the national, but based upon the color of skin. All right, based upon the color of skin. Can everyone see this? All right, Bishop, make sure you put the template for the last video as well as this one. I didn't see it. Okay, yeah, you got this one. All right, you're on time, boy. You're on time, Archbishop. Children versus Georgia. I want y'all to really understand how much power I have as your king, and that they're finally starting to see the power that I have as your king. All right. It's right here in the Chisholm versus Georgia, which was here before the founding of their establishment. Okay. It says here, this great cause comes before the court on a motion made by the Attorney General that an order be made by this court to the following effect. Before such an order be made, it is proper that this court should be satisfied it has cognizance of the suit. For to be sure, we ought not to enter a conditional judgment, which this would be in a case where we were not fully persuaded we had the authority to actually do so. Okay? The action was the action of assumption, which means a trespass. An action of assumption dealing with trespass as well as unjust enrichment. Okay? Trespassing and unjust enrichment. And the case was brought when you get time, boo. The case was brought to see if the state can be brought up on an action or something. All right. So the action is an action of a something. The particular question then before the court is, will an action of a something lie against the state? This particular question abstracted from the general one, whether a state can in any instance be sued. Okay, because they say the state's the sovereign. But the Attorney General must know that in England, certain judicial proceedings not inconsistent with the sovereignty may take place against the crown, but that an action of a substance will not lie. Once again, but the Attorney General must know that in England, certain judicial proceedings not inconsistent with the sovereignty may take place against the crown, but that an action of a substance, i.e., trespass and unjust enrichment, will not lie against the king. All right? Yet surely the king can assume as well as the state. So can the United States themselves, as well as any state within the Union. Yet the Attorney General himself has taken some pains to show that no action whatever is maintainable against the United States. All right, we're going to prove him wrong with this case. The question, as I before observed, is will an action of a something lie against a state? If it will, it must by virtue of the Constitution of the United States and some law of Congress conformable thereto. The part of the Constitution concerning the judicial power is as follows. Article 3, Section 2. The judicial power shall extend to controversies between two or more states, between a state and a citizen of another state, between citizens of different states, between citizens of the same state, claiming lands under grants for different states, and between a state or the citizens thereof and foreign states, citizens or subjects. You hear that? Article 3, Section 2 deals with the authority that Congress had that the Constitution abided in them. All right? It's very important that you understand what's going on in regards to your due process of law, due process that you receive from the courts of law based upon your legal status. So if you're an alien, if you're an immigrant, and if you're a foreigner, you're going to get the same due process of law as a United States citizen or a state citizen because it actually doesn't mean citizenship based upon national principles that a citizen have if he was a national, but actually that which pertains to our permanent allegiance. Y'all better listen. Okay. The only principles of law then that can be regarded are those common to all the states. I know of none such which can affect this case, but those that are derived from what is properly termed the common law. A law which I presume is the groundwork of the laws in every state in the Union, and which I consider so far as is applicable to the peculiar circumstances of the country, and where no special act of legislation controls it to be enforced in each state as it existed in England, unalterated by any statute at the time of the first settlement of the colony. Did y'all hear that? Unalterated, unadulterated. Okay? Very important. Let's qualify what Chisholm in Georgia by going to another court case. United States versus Sing Trump. United States versus Sing Tuck or Dude, 1904, dealing with a Chinese man. A Chinese man claiming citizenship based upon the Naturalization Act. Okay? The Naturalization Act. Parts of not the Naturalization Act, the Immigration Act. The Immigration Act. All right? This is what this case refers to. So let's go to and read it in its not in its entirety, but in the brief. We're gonna start here. Can anything be more harsh and arbitrary? Coming to a port of the United States, as these petitioners did into the port of Malone, placed as they were in a house of detention, shut off from the communication with friends and counsels, examined before the inspector with no one to advise or counsel, only such witnesses present at the inspectors may designate. and upon an adverse decision, compelled to give notice of appeal within 2 days. Within 3 days, the transcript forwarded to the Commissioner General, and nothing to be considered by him except the testimony obtained in the Star Chamber proceeding. You hear that? In the Star Chamber proceeding. This is called due process of law to protect the rights of an American citizen and sufficient to prevent inquiry in the court. Okay, so this is a due process of law that this Chinese man received based off the immigration laws that were actually based upon the principles as established by the Star Chamber. Okay, and the Star Chamber was established in the 15th century. All right, by Parliament under the Commonwealth. Let's prove it. Star Chamber. Influence of the Star Chamber on the United States Constitution. Historical abuses of the Star Chamber are considered to be some of the reasons, along with English common law precedents, behind the protection against compelled self-incrimination embodied in the Fifth Amendment to the United States Constitution. The meaning of compelled testimony under the Fifth Amendment, i.e., the conditions under which a defendant is allowed to plead the Fifth to avoid self-incrimination, is thus often interpreted via reference to the inquisitorial method of the Star Chamber. As the United States Supreme Court described it, the Star Chamber has for centuries symbolized disregard of basic individual rights. The Star Chamber not merely allowed but required defendants to have counsel. Isn't that pretty much what you do today? The defendant answer to an indictment was not accepted unless it was signed by counsel. When counsel refused to sign the answer for whatever reason, the defendant was considered to have confessed to the actual guilt. In addition, the excessive bail on the Articles of the Bill of Rights of 1689 was reproduced near verbatim as the Eighth Amendment of the United States Constitution, which formed part of the United States' own Bill of Rights, dealing with what we're talking about, the Star Chamber. Okay? Very important we understand what's going on. Back to the court case. But it is said that the applicants did not prove before the immigration officer that they were citizens, that some simply alleged the fact while others said nothing, that they were told that if they would give the names of two witnesses, their testimony would be taken and considered. But what provisions of law is there for compelling the attendance of witnesses before such immigration officers or for taking disposition, and of what avail would be an ex parte inquiry of such a witness? Must an American citizen seeking to return to this his native land be compelled to bring with him two witnesses to prove the place of his birth? I repeat, must an American citizen seeking to return to this his native land be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return? And all opportunity in establishing his citizenship in the court of his country? Question. No such rule is enforced against an American citizen of Anglo-Saxon descent. And if this be, as claimed, a government of law and not of men, I do not think it should be enforced against American citizens of Chinese descent based upon the laws dealing with immigration. We know that Anglo-Saxon citizenship is different from American citizenship based upon whatever clause they use, whether it's the Naturalization Act of 1790, whether it's the 14th Amendment, or whether it's the Immigration Act. It's not the same as the ascent of Anglo-Saxon who are also classified as American citizens, because you got a lot of people classified as American citizens, but the only true American citizen is one of Anglo-Saxon descent. You must understand that. All right? You must understand that. It says no rule is enforced against American citizens of Anglo-Saxon descent. And if no rule, You don't have to prove it by some type of rule. We know that the 14th Amendment Citizenship, the Naturalization Act, and the Immigration Act were based upon a rule, and we call that rule a statutory law. Okay? We must understand what's going on. Let's go back to the court case. Oh, I wanted to go ahead. We know here in Ray Ahmad versus Hassan, still talking about citizenship. It says to summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute as interpreted by the Supreme Court. It is necessary to determine first a particular group or racial subdivision to which the individual belongs. In practical effect, proof of this fact is a matter of genealogy. An individual who presents an aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or a Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the act from other members of its group. We see the Chinese and the United States versus Sing talk in regards to citizenship, it clearly said that there's no rule in regards to Anglo-Saxon making a claim of a citizenship in court in regards to standing to back to its homeland here in North America, and it should not be the same for a Chinese, because we know Chinese is his nationality. He just happened to be light skinned or fair skinned, what you call white skin, which was based upon the Naturalization Act. So we got three qualifications based upon the Anglo-Saxon and the origin of citizenship, because when you go back to citizenship, citizenship was coagulated based upon within the Anglo-Saxon world. That's what they said. The Anglo-Saxon world. Dual citizenship is often legally conflated with nationalities of other kinds in today's Anglo-Saxon world. I hope y'all all see the picture that I am painting for you, brothers and sisters. All right? Because you have a choice to make in regards to the citizenship. So choose wisely, because the choice is in your hands. Very important for you to understand what I'm saying to you today. Let's read on. The statutes of England that are enforced in America differ perhaps in all the states, and therefore it is probable the common law in each is some respect different. But it is certain that in regards to any common law principle which can influence the question before us, no alteration has been made by any statute which can occasion the least material differences or have any partial effect. No other part of the common law of England, it appears to me, can have any reference to this subject but that part in which prescribed remedies against the crown. Did you hear that? The crown. Every state in the Union, in every instance where its sovereignty has not been delegated to the United States, I consider to be a completely sovereign, as the United States are with respect to the powers surrendered. The United States are sovereign as to all powers of government actually surrendered. Each state in the Union is sovereign as to all the powers reserved. It must necessarily be so, because the United States have no claim to any authority but such as the states have surrendered to them. Okay? Of course, the part not surrendered must remain as it did before. The power of the general government, either of the legislative or the executive nature, or which particularly concerns treaty with foreign powers, do for the most part, if not wholly, affect individuals and not the state. I repeat, the powers of the general government, either of legislative or executive nature, and which particularly concerns treaty with foreign powers, do for the most part and wholly affect individuals and not the state. They require no aid from any state authority. This is the great leading distinction between the old Articles of Confederation and your present state constitutions. Okay? Everyone needs to understand this, because your citizenship is based upon that. If therefore no remedy be provided, as plainly in this case, and consequently we have no other rule to govern us but the principles of the pre-existing laws, which must remain in force till superseded by others, then it is incumbent upon us to inquire whether previous to the adoption of the Constitution, which periods or the periods of passing the law in respect to the object of this inquiry and perfectly equal, an action of the nature like this before the court could have been maintained against one of the states in the Union upon the principles of the common law, which I have shown to be alone by itself without any other assistance applicable. All right? Applicable. If I could, I think it not maintainable here. If I could not, I think as the law stands at present, it is not maintainable, whatever opinion may be entertained. Upon the construction of the Constitution as to the powers of Congress to authorize such a one, now I presume it will not be denied that in every state of the Union, previous to the adoption of the Constitution, the only common law principles in regard to suits that were in any manner admissible in respect to the claim against the state were in those which in England apply to claims against the crown. There being certainly no other principles of the common law which, previous to the adoption of this Constitution, could in any manner or upon any color apply to the case of a claim against a state in its own courts, where it was solely and completely sovereign in respect to such case at least. Whether that remedy was strictly applicable or not, still I apprehend there was no other. The only remedy in a case like that before the court by which by any possibility a suit can be maintained against the Crown of England or could be at any period from which the common law as enforced in America can be derived, I believe it was that which I call a petitioner right. It is stated indeed in Commons Digest, page 101, that until the time of Edward the First, the king might have been sued in all actions as a common person. By all these authorities, and by many others which I could cite, both ancient and modern, it is plain that if the subject was to recover a rent or annuity or other charge from the crown, whether it was a rent or annuity originally granted by the king or issued out of lands which by subsequent title came to be in the king's hands, in all cases, the remedy to come at it was by petition to the person of the king, and no other method could be shown to have been practiced at the common law. Indeed, I take it to be generally true that in all cases where the subject is in the nature of the plaintiffs to recover anything from the king, his only remedy at the common law is to sue by petition to the person of the king. I say where the subject comes as a plaintiff. For as I said before, where upon a title found for the king by office, the subject comes and traverses the king's title, or to show his own right, he comes in the nature of a defendant and is admitted to interplead in the case with the king in defense of his title, which would otherwise be defeated by the finding of office. We see that in Fairfax Devizes versus Hunter Leslie. Let's just go back to that case real quick, which we talked about yesterday in my lecture. Fairfax, Devizes, and Hunter. An alien enemy may take lands in Virginia by devise and hold the same until office is found. The same thing they just said in Chisholm versus Georgia. The Commonwealth of Virginia could not grant the unappropriated lands in the Northern Neck until its title should have been perfected by possession. And the British Treaty of 1794 confirms the title to those lands and the devisees of Lord Fairfax. An alien can take land by purchase, though though a not by descent. As the common law, or in other words, he cannot take it by an act of law, but he may by an act of part, by act by but he may by an act of a party. There is no distinction whether the purchase should be by a grant or devisee. In either case, the state vests in the alien not for his own benefit, but for the benefit of the state. Or in the language of the ancient law, he has the capacity to take, but not to hold land, and they may seize it to the hands of the sovereign. Until the lands are so seized, the alien has complete dominion over them. He is a good tenant of freehold and the preside of a common recovery. This means death by way of stealing land that's entailed and making it fee simple, and may convey the same to the purchaser. It seems indeed to have been held that an alien cannot maintain the real action for recovery of the land, but it does not then follow that he may not defend the real action of his title to the land against all persons other than the king. All right? Anybody else other than the king. The title acquired by the alien by purchase is not divested until the office is found. The principle is founded upon the grounds that as the freehold is in the alien and he is a tenant to the lord of whom the lands are holding, it cannot be divested out of him but by some notorious act by which it may appear that the freehold is in another. So we know that in order for the land to return back to the sovereign, office must be found, or in quest of office. If it's not, then that means that those who are aliens can take the land by way of purchase, and we call that prescription. All right? Prescription. Very important. Office found. Office found means the return of a verdict by inquest of an office, which is also called inquest of office. An inquest of office is an inquiry conducted by the king's officer, coroner, sheriff, or other royal officer into matters affecting the rights and interests of the crown or of the state to the possession of the lands of tenements, goods, or chattels. This is very important because we must understand that whoever stole this land took it from the actual owners. All right, we go to Jones versus Vidal to establish this case. This point, I mean, Downs versus Vidal, 1901 case. Check this out, my brothers and sisters. We are also of opinion that the power to acquire territory by treaty implies not only to the power. Remember, treaties only apply to individuals, not the state, as we see it in Chisholm versus Georgia, which we'll go back to in a second. We are also of opinion that the power to acquire territory by treaty implies not only the power to govern such territory, but to prescribe upon what terms the United States will receive its inhabitants. You hear that? And what their status should be in what Chief Justice Marshall termed the American Empire. Before you had the American Empire, you had what? The British Empire. And the British Empire was the extension or offshoot of the English Empire. There seems to be no middle ground between this position and the doctrine that if their inhabitants does not become immediately upon annexation citizens of the United States, their citizens thereafter born, whatever savages or civilized, are such and entitled to all rights and privileges and immunities of citizens. If such be their status, the consequence will be extremely serious. Indeed, it is doubtful if Congress will ever assent to the annexation of the territories upon conditions that its inhabitants, however foreign they may be to our habits, traditions, and modes of life, shall become at once citizens of the United States. In all its treaties hereto, the treaty making power has made special provision for this subject in the case of Louisiana, Florida, by stipulating that the inhabitants to be incorporated. You hear that, y'all? Incorporated into the Union of the United States and admitted as soon as possible to enjoy all enjoyment of all the rights, advantages, and immunities of citizens of the United States, not as citizens, but as national through your pledges of allegiance. Okay? Through your pledges of allegiance. In the case of Mexico, they should be incorporated into the Union and be admitted at the proper time to be judged of by the Congress of the United States to the enjoyment of all rights of citizens of the United States. Do y'all hear what I'm reading to y'all tonight? Grave apprehensions of dangers are felt by many eminent men. A fear lest an unrestrained possession of powers on the part of Congress may lead to an unjust and oppressive legislation in which the natural rights of territories or their inhabitants may be engulfed in a centralized disposition. These fears, however, find no justification in the actions of Congress in the past century, nor in the conduct of the British Parliament towards its outlying possessions since the American Revolution. Indeed, in the only instance in which the court has declared an act of Congress unconstitutional as trespassing upon the rights of the territories, action of assumption, Chisholm versus Georgia, such action was dictated by motives of humanity and justice, and so far commanded popular approval as to be embodied in the 13th Amendment to the Constitution. Did y'all hear that? Of the Constitution. There are certain principles of natural justice inherited in the Anglo-Saxon character which need no expression in constitution or statute to give them effect or to secure dependency against legislation manifestly as hostile to the real interest. Did y'all hear what I just read? There are certain principles of natural justice inherited in the Anglo-Saxon character. When you say inherited, that means that you are an heir. Okay? That's intel. That's a birthright. All right? Coming along with the nationality of an Anglo-Saxon, and in this day and time, they're Berbers. There are certain principles of natural justice inherited in the Anglo-Saxon character which need no expression in constitution or statute to give them effect or to secure dependency against the legislation manifestly hostile to the real interest. Even in the Four-Actor Act itself, the constitutionality of which is so vigorously assailed power was given to the Legislative Assembly of Puerto Rico to repeal the very tower in question in this case, and the power has not since fit to exercise. The word of Chief Justice Marshall, with respect to the power of Congress to regulate commerce, are pertinent in this connection. This power, said he, like all others vested in Congress, is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than as prescribed in the Constitution. The wisdom and discretion of Congress, their identity with the people, and their influence with their constituent possessors at elections are in this, as in many other instances, as that, for example, of declaring war, the sole restraints on which they have relied to secure them from its abuse. They are the restraints of which the people must awfully rely solely in all representative governments. Did you hear that? Did you hear that? Check this out. The title by conquest is acquired and maintained by force. The conquest prescribed its limits. Humanity, however, acting on public opinion, has established as a general rule that the conquered shall not be wantonly oppressed and that their condition should remain as eligible as it is compatible with the object of the conquest. This means prescription. Most usually, they are incorporated with the victorious nation and become subjects or citizens of the government with which they are connected. So, in that brings me up to this. Acquisition of sovereignty by way of prescription, which calls by way of eminent domain, which is actually based upon the laws of discovery. Okay? Very important for y'all to understand that. Let me go back to where I was. I don't know where it went to. Acquisition of sovereignty or prescription of sovereignty only originated because they said there were no more Anglo-Saxon Berbers here in North America. So that means as a result of that, all the land is ceded to the state of New Jersey. All right, which it in the street, they stole it by alienating us from our nationality by way of classifying us based upon giving us a new legal status as persons based upon the pledges of allegiance to the new government as established by the founding fathers based upon their interpretation of citizenship, knowing damn well that citizenship should be based upon the Anglo-Saxon world. Okay? The Anglo-Saxon world. We know that it exceeded to the state of New Jersey, knowing damn well they don't have the power to exceed. How we know that? Let's go to State of Parsons versus uh, Standard Oil Company. And modern usage, its street signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which, what happened? I thought I shared it. 1 second. Yeah. Owners embrace not only property which has no other owner, but also property whose owner or whose owner's whereabouts is unknown. Under the common law of England, a street came to be classified as another branch of the king's ordinary revenue. What was originally an incident of tenure is now an incident of sovereignty. All right, incident of sovereignty. The doctrine of receipt at the earliest common law operative only upon that which was the subject of tenure, since related to the reversionary right of the lord to take for one every tenant, was eventually extended to include personal property, tangible and intangible. You hear that? Personal property, tangible and intangible. The principle was that the right to take that which belonged to no one appertained to the crown, as jewel regalia. The crown steps in to take the property because it is vacant. Property described as bona vacantina is taken or assumed by the state, actually assumpted as its own. Property of the class falls to the crown as a matter of right, as an exercise of its sovereign power. In personal estates which are allotted by law, the king is last heir where there is no kin. All right? He's last heir when there is no kin. That means ain't no more fiddle tenures and the land has remained elodio. All right? Elodio. Very important for you to understand that. All right? Let's see where we at. Back to Doan versus Bidwell. So it says the title by conquest is acquired and maintained by force. The conquerors prescribed its limits. Humanity, however, acted on the public opinion, has established as a general rule that the conquered should not be wantonly oppressed and that their conditions should remain as eligible as it is compatible with the object of the conquest, i.e., prescription. Most usually, they are incorporated with the victorious nation and become subject or citizens of the government with which they are connected. So it says here, we have been incorporated because those who conquered England have become victorious and now have claimed the nationality of the national, and now we classify the nationals under the nationality that they have deemed it, was nothing more based upon a pledge of allegiance and not actual citizenship that deals with some type of due process of law or protection at law. The new and old members of society mingle with each other. The distinction between them is gradually lost, and they make one people. See that mixture? That mixture is a came about by a chemical reaction, which was not a good result. Where this incorporation is practicable, humanity demands and wise policy requires that the right of the conquered to property should remain unimpaired and that the new subject should be governed as equitable as the old, and that confidence in their security should gradually banish the painful sense of being separated from their ancient connection and united by the force to strangers. Do you hear that? When the conquest is complete and the conquered inhabitants can be blended with the conquered or safely governed as a distinct people, public opinion, which not even the conqueror can disregard, imposes these restraints upon him, and he cannot, I repeat, and he cannot neglect them without inquiry to his fame and hazard to his power. Did y'all hear that? The following remarks of Mr. Justice White in the case Knowlton versus Moore, in which the court upheld the progressive features of the legacy tax, are also pertinent. The grave consequences which is asserted must arise in the future of the right to levy a progressive tax by recognized involved in its ultimate aspect the mere assertion that free and representative government is a failure and that the gross set abuse of power are foreshadowed unless the courts usurp a purely legislative function. If a case should ever arise where an arbitrary and confiscatory exaction is imposed bearing the guise of a progressive or any other form of tax, it will be time enough to consider whether the judicial power can afford a remedy by applying inherited the fundamental principle for the protection of the individual, even though they by no expense authority in the Constitution to do so. All right. It's obvious that in the annexation of outlying and distinct possessions, grave questions will arise from differences of race, habits, laws, and customs of the people, and from difference of soil, climate, and production, which may require actions on the part of Congress that will be quite unnecessary in the annexation of contiguous territories inhabited only by people of the same race or by scattered bodies of native Indians. We suggest, without intending to decide, that there may be a distinction between certain natural rights enforced in the Constitution by prohibitions against interference with them and what may be termed artificial or remedial rights, which are peculiar to our own system of jurisprudence. You hear that? What term artificial or remedial rights, which are peculiar to our own system of jurisprudence. Of the former, i.e., artificial form of the former class, i.e., artificial, are the rights to one's own religious opinion and to the public expression of them, or as sometimes said, to worship God according to the dictates of one's own conscience, the right to personal liberty and individual property, to freedom of speech or the press, or to free exercise of the courts of justice, to due process of law, and to an equal protection of the laws, to immunities from unreasonable searches and seizures, as well as cruel and unusual punishment, and to such other amenities that are indispensable to a free government. But that's based upon, once again, your classification of citizenship, whether it's artificial or whether it's remedial. The latter, i.e., remedial class, are the rights to citizenship, to suffrage, and to the particular methods of procedures pointed out in the Constitution, which are peculiar to Anglo-Saxon jurisprudence, and some of which have already been held by the state to be unnecessary to the proper protection of individuals. You hear that? So they're not worried about using the jurisprudence that originated from common law of England, which is called Anglo-Saxon jurisprudence, as a result of the classification of citizenship that they reclassify the Anglo-Saxon purpose in this present day. Okay? Very, 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 very important for you to understand that. Whatever may be finally decided by the American people as to the status of these islands and their inhabitants, we just read that there is no rule of law in regards to proving citizenship as they're here in these lands based upon American citizens known as from American Anglo-Saxon descent. We already read that. All right? There is no rule. There is no constitution. There is no statute in regards to the Anglo-Saxon because according to citizenship, all citizenship is based upon the Anglo-Saxon world. Whatever may finally decide by the American people as to the status of these islands and their inhabitants, whether they should be introduced into the sisterhood of the states or be permitted to form independent governments like we did, it does not follow that in the meantime, awaiting that decision, the people are, in the matter of personal rights, unprotected by the provisions of our Constitution and subject to the merely arbitrary control of Congress. Did you hear that? It does not follow that in the meantime, awaiting that decision for the people to rise up from their own government, until that time, people are in the matter of personal rights unprotected by the provisions of our Constitution and subject to the merely arbitrary control of Congress. Even if regarded as aliens, They are entitled under the principles of the Constitution to be protected in life, liberty, and property. This has been frequently held by the court in respect to the Chinese, even when aliens not possess of the political rights of citizens of the United States. So they have y'all all in one big bunch. Okay? One big bunch. We do not desire, however, to anticipate the difficulties which would naturally arise in this connection, but merely to disclaim any intention to hold that the inhabitants of these territories are subject to an unrestrained power on the part of Congress to deal with them upon the theory that they have no rights which is bound to be respected. Did you hear that? Bound to be respected. So in closing, so in old authorities, there does not appear in any distinction between debts that might be contracted personally by the king for his own private use and such as he contracted in his political capacity for the service of the kingdom, as he had, however, then fixed in independent revenues upon which depended the ordinary support of government as well as the expenditures for its own private occasions. Probably no material distinction at that time existed or could easily be made. Pardon so. A very important distinction may, however, perhaps now subsist between the two cases for the reason intimated by Lord Mansfield, since the whole support of government depends now on parliamentary provisions, and except in the case of the civil lists, those for the most part annual. Thus, it appears that in England, even in the case of private debt contracted by the king in his own person, there is no remedy but by petition, which must receive his express sanction. Otherwise, there can be no proceedings upon it. You hear that? Now, let us consider the case of a debt due from the state. None can, I apprehend, be directly claimed but in the following instances. First, in the case of a contract with the legislature itself. Second, in the case of a contract with the executive or any other person in consequence of an express authority from the legislator. Third, in the case of a contract with the executive without any special authority, which is the case. In the first and second case, the contract is evidently made on the public faith alone. Every man must know that no suit can lie against the legislative body. Okay? His only dependence, therefore, can be that the legislator, on principles of public duty, will make a provision for the execution of their own contract. And if that fails, whatever reproach the legislator may incur, the case is certainly without remedy in any court of the state. It never was pretended, even in the case of the Crown of England, that if a contract was made with Parliament or with the Crown by virtue of authority from Parliament, that petition to the Crown would in such case lie. In the third case, a contract with the governor of a state without any special authority. This case is entirely different from such contract made with the crown in England. The crown there has a very high prerogative. In many instances, it's a kind of trustee for the public interest. In all cases, represent the sovereignty of the kingdom and is the only authority which can sue or be sued and in any manner on behalf of the kingdom in any court of justice. A governor of a state is a mere executive officer. His general authority very narrowly limited by the Constitution of the state, with no undefined or disputable prerogative, without power to affect 1 shilling of the public money, but he is authorized under the Constitution or by a particular law having no color to represent the sovereignty of the state so as to bind in any manner to its prejudice unless special authorized thereto. Pay close attention. And therefore, all who contract with him do it at their own peril. I repeat. And therefore, and that includes citizens as well. And therefore, all who contract with them do it at their own peril and are bound to see or to take the consequences of their own indiscretion. That he has strict authority for any contract he makes. Of course, such contact, when so authorized, will come within the description I mentioned of cases where public faith alone is the ground of relief, and the rest of the body, the only one that can afford a remedy, which is from the very nature of it, must be the effect of its discretion and not of any compulsory process. Why do I say that? Let's go to Billen versus Harris. The state, let me start here. Since the federal courts are not courts of general jurisdiction possessing all powers of the king's bench, the accumulation of precedents and the general field are somewhat nebulous, especially since the law in each of the circuit is controlled by the decision of the Court of Appeals, and in particular circuits until such time and as a decision of the Supreme Court of the United States resolve difference between the circuit. The state of New Jersey, whose boundaries coincide with those of the district, is one of the original 13 states of the Union and is a common law state. This structure of its laws may be looked at for a general background about prerogative writs and general the writ of certiorari or a petition for certification in particular. New Jersey, the first constitution adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. Article 22 of the Constitution continued the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely instructed in content of the Constitution of the United States by Article 10, Paragraph 1. It too continued in force the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, Paragraph 3 continued to force the existing law. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, and we know the Constitution of 1844, the United States Constitution, the model in lieu of that frame, was vested with all the power of the King's bench, which the legislator was powerless to cut down or to sign to other courts, i.e., administrative court. This principle was especially strong in the field of prerogative writs, of which certiorari was the most frequently sought. Back to the court case. In closing, is, however, in any such case where similar to those which would entitle a party to relief by petition to the King of England, that petition being only presentable to him as he is the sovereign of the kingdom, so far as analogy is to take place. Such petition in a state can only be presented to the sovereign power, which surely the governor is not. Did you hear that? So the governor ain't got no power, according to what we're reading here in Chisholm versus Georgia. The only constituent authority to which such an application could, with any propriety, be made must undoubtedly be the legislator, who expressed consent upon the principles of analogy would be necessary to any further proceedings, so that this brings us, though by a different route, to the same goal, the discretion and good faith of the legislative body. There is no other part of the common law besides that which I have considered, which can by any person be pretended in any manner to apply to this case, but that which concerns corporations. The only laws concerning corporations to which I conceive the least reference is to be had is the common law of England on the subject. I need not repeat the observation I made in respect to the operation of law in this country. The word corporation, in the larger sense, has more extensive meaning than people generally are aware of. Yes, the state is a corporation or organization. All the agencies that were created by the United States and the states are a corporation or an organization. And all that was overturned by the Chevron decision. So we must understand that the word corporation, in larger sense, has more extensive meaning than you know. And you should really know what it means, because without that knowledge, you won't have any legal status based upon your affiliation with that body of politics, based upon a social contract, which impacts your life based upon your legal status, which is dependent on your citizenship. So it says the word corporation, in the larger sense, has more extensive meaning than people generally are aware of. Any body of politics, sole or aggregate, whether its power be restricted or is transcended, is in this sense a corporation. The king, accordingly, in England is also called a corporation so. So also by very respectful authority is Parliament itself. That's the aggregate. In this extensive sense, not only each state singly, but even the United States may without impropriety be termed also a corporation. I have therefore, in contradiction to this large and indefinite term, used the term subordinate corporation, meaning to refer to such only as only capable of the slightest application for the purpose of the objection, whose creation and whose power are only limited by the law, the Constitution. So, in closing, the difference between such corporations and the several states in the Union as relative to the general government are very obvious in the following particulars. First, a corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. It owes its existence, its name, and its laws, except such laws that are necessary incidents to all corporations, merely as such to the authority which created it. A state does not owe its origin to the government of the United States and the highest or in any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary, deliberate choice of the people. Second, corporations can do no act but what is subject to the revisions either of the Court of Justice or some other authority within the government. A state altogether exempted from the jurisdiction of the Court of the United States or from any other exterior authority unless in special instances where the general government has power derived from the Constitution itself. Third, a corporation is altogether dependent on the government to which it owes its existence. Its charter may be forfeited by abuse, its authority may be annihilated without abuse by act of legislative body, not the executive, not the judicial, but the legislative body. So, in closing, a state, though subject in certain specified particulars to the authority of the government of the United States, is in every other respect totally independent upon it. The people of the states created the people of the states can only change its constitution. Upon this power, there is no other limitation but that imposed by the Constitution of the United States. So, in closing, only the king can save his people. Because in order for you to honor the king, you must be the king's people, and that's based upon the citizenship that's based upon that of the common law. And I'll show that one more time, and then we're closed. Right. Common law jurisdiction. If you don't follow the laws of the minor or the laws of parliament, which is the laws of the government for all those who are subject of the government, then you are classified as an alien. And English law denotes to any person born outside of the minor's dominion and who did not owe allegiance to the minor. Aliens were not allowed to own land and were subject to the different taxes, i.e., encumbrances of the subject. We call that free and common socis. This idea was passed on to what you call a republic, which came from a commonwealth to other common law jurisdictions. So in that, we must understand that all of them are subject to what we call the statutes of frauds. The statutes of fraud. How many of you are heard of the statutes of fraud? And closing. The Statute of Frauds was an act of the Parliament of England. It required that certain types of contract, wills, and grants and assignments or surrender of leases or interests in real property must be in writing and signed to avoid fraud on the court by perjury and subordination of perjury. They also required that documents of the court be signed and dated. This law was passed on April 16, 1677, the same day we incorporated as a government. August 16th, April 16th. All right here. 4/16/2022. All right. So this is a contract. This is subject to the statute of frauds. All right. So we must understand that if you're not a subject of the monarch and you're a citizen of the state, United States, the colonies, or receive citizenship by way of immigration, then you are an alien and you have no right to any estate here, what we call North America. And with that, we must understand that this is the only way to break the matrix. The only way to break the matrix. According to the 1911 Encyclopedia Britannica, matrix is a word of somewhat wide application, chiefly used in the sense of a bed or enclosed mass in which something is shaped or formed. We go back to the medieval Latin. Matrix, diminutive matricula, had the meaning of a roll or a register, particularly one containing the names of the members of the institution, as of the clergy belonging to the cathedral, collegiate, or other church, or other members of the university, from the usage derived matriculation, the admission to membership of the university, also name of the examination for such admission. So the examination for admission is what you're hearing today in regard to your rights to become a citizen of England, known as the Anglo-Saxon Berbers and members of the Third Temple English Church of England. And with that, you must satisfy a great burden. Okay? You must satisfy a great burden. So with that, I'm agreed with you as I meet with you as always in peace and love. Archbishop, thank you for moderating. All those who are striving to understand this, reach out to the Third New England Church, leave your name and number. We also do live classes. We do lectures as well as I do private classes. All right, so reach out to the Third New England Church and we can get that underway. All right, so with that, I say peace.